Ms. Wiley, I'll just remind you that you remain under the oath that I previously gave you. So go ahead and have a seat. Go ahead, Mr.
Thank you. So, Deborah, similarly as I did with Krista, I just want to give you some time to move more slowly through the events that occurred regarding ServPro. All right. So, what do you remember about April 20th, 2024?
Not a thing.
Do you remember learning about water in the basement?
When I got up, he said there was water in the basement. We had no heat.
Did you see it for yourself?
No, I did not go. I don't go down those stairs.
Okay.
I would probably fall down.
And so when ServPro came out, were you at home?
I don't recall if I was at home or if I had left and gone to work.
Do you normally work during the day?
Yes, I usually leave the house about noon,
Okay.
and I don't get home till after like 10:30 at night.
So did you ever have any interactions with any of the ServPro
No,
people?
I did not.
Did you ever get anything in the mail from ServPro?
I hardly ever get my mail because it's always picked up for me by my daughter, so I did not receive anything.
All right. What about email? Do you do email?
No,
Do you do text messages?
no, I don't know. I'm old school. All right.
So now this contract, Exhibit 3, had you ever seen this before?
No, I've never seen any contracts whatsoever.
Would you have, how did you obtain notice of this lawsuit?
When I was served papers?
All right. Did you read through the papers when you were served with them?
No, I did not.
Why not?
Because it was mostly my daughter that had set it all up and that night, I did not go through it.
All right. So at any time, did you learn that this agreement called for a mechanical lien against your home?
I have no idea what a mechanical lien is, and I never knew that there was a lien against the home until it was mentioned to me by my daughter.
And so what was your initial reaction when you learned about that?
I have no idea what the lien means.
All right.
So I had no reaction. I thought, well.
So when did you learn that this contract signed by Krista as Exhibit 3 required a 1.5% monthly charge?
I never ever knew anything about it.
Do you believe that? I'm sorry, I strike that. What about that the agreement allowed Krista to pay legal fees if ServPro engaged in collection actions? When did you learn about that?
I never heard anything about it. All I know is that my daughter tried to set up a payment plan to pay it back.
So do you believe that any of these terms of the contract applied to you?
I never signed any contract, and so I have no idea what any of it means.
So do you know what work ServPro actually did do on your home?
They took the water out.
All right. And did you actually ever see them on your property or in your home?
No. Like I said, most of the time I'm not home.
Did you see any of the equipment that ServPro
Yes,
used?
whatever, the big generator, whatever it was that was left out on our porch.
All right.
And I asked my daughter, I said, why is it still here? And she said, well, they haven't come to pick it up yet. So,
Now, during this whole incident, did you have any contact with your insurance company?
my daughter did all the contact with the insurance company.
Did you have any contact with any of the other contractors, like for the water heater or the jet pump or
No.
anything like that? So since April 20th, 2024, when this incident began, have you been down in the basement at all?
I never go down there. I had no reason to go down there.
Did you receive any bill from ServPro?
I never personally saw a bill from them.
When did you learn that ServPro had filed a construction lien against your home?
When my daughter told me about it, and I don't remember the date that was.
What was your first reaction about learning of the construction
Well,
lien?
she was pretty upset with it because I had no reason why to have a lien against our house.
What about you? How did you feel?
Judge, I'll object to relevancy.
I guess for purposes of the, I mean, to the extent it asks for an emotion, that's not really relevant, but I think he's getting at proving the factual predicate for the Consumer Protection Act counterclaim.
So yeah, you told us what Krista's response was. What was your response about learning about the construction lien?
Well, if I don't know anything about what it means, I had no response.
So once you learned about that, did you direct Krista in any way as to resolve it?
No.
So what do you believe is a fair resolution of this case against you, Deborah?
I had none.
Why is that?
Well, I never had any contact with anybody about anything that went on in the house, so why should I be responsible? Just because I'm the homeowner?
All right, so I don't have any other questions for you.
Any cross example?
Deborah, you gave Krista permission to call ServPro to have them come out and get the water from the basement in your home.
Yes.
Those are all my questions. Thank you.
Okay, any redirect on, or
No, thank you.
Go ahead and step down there.
Well,
Mr. Kadan?
No other witnesses, Your Honor.
Oh, thank you. Mr. Slough, any rebuttal proofs?
None, Your Honor. Thank you.
Okay, do you want to take a recess before we take closings to gather thoughts, or are you ready to go?
I'm ready to go, Judge. I mean, I think
Okay.
we briefed this pretty thoroughly. I just want to hit the high points. and-
Sure, go ahead
and
with
leave it to you.
closing.
Judge, this is a frustrating case because there's really no dispute. My client provided the services. They provide them in a good workman-like manner. And in fact, they were paid by the insurance company. And yet, for whatever reason, the Wileys refused to pay the deductible on their insurance and they're leaving that on ServPro. And then on top of it, they're running up the costs by putting ServPro through this litigation. The Construction Lien Act, its primary purpose is to ensure payment to the contractor. Got a situation here where it's an emergency situation. You heard the Wileys testify to that. ServPro is responding to try to address this flood in the basement that's happening. There's no heat, there's no electricity to the home. And certainly there's issues with how this Construction Lien Act, or excuse me, this construction lien was filed. But again, the act only requires substantial compliance. And the reason for that is, again, contractors are often being called out to respond, especially a contractor like ServPro. What it does is it responds to emergencies. So, there's got to be some flexibility there to effectuate the purpose of the act. The one exception to that is, of course, the 90-day deadline. That's what the case law says. I think that's the biggest issue here, is whether or not services, material, labor was provided within that 90-day period. And you heard the testimony that it was. In fact, ServPro provided a heating unit to the Wileys. Their furnace was not working. It was May in northern Michigan. It very well could have been cold, and they had animals in the house, so they needed some assistance. ServPro stepped up and went above and beyond and tried to help them out by giving them this heating unit.
Was that service connected to the service for which they didn't charge? Was that connected to the contracted services at all?
It was, it was really not, in the sense that it had nothing to do really with cleaning the water in the basement. But it was a service that they provided because they were a contractor and they were there trying to help their customer. The fact it was connected in the sense that the furnace and the electricity were off in the home because of that water flooded in the basement. And so as they were finishing up the mitigation of the water, they recognized the customer had this additional problem. That happens all the time in construction jobs, where you dig in and realize that there's other issues that have to be addressed. And one of the issues they had to address was the fact that there's no heat.
Sure,
So,
but if your client's business consisted of we provide temporary heating solutions in emergent situations, and they show up and put a monstrous electronic heater that can heat a 1,600 square foot home, they wouldn't be entitled to a construction lien for that service, right?
oh, I think they would be. I think they would be, absolutely.
You think they would? You have a very expansive view of the Construction Lien Act.
Well, I do, because I think that the act has a very expansive definition of
What
improvement.
about somebody that goes and does carpet cleaning? Are they entitled to a construction lien?
Let me phrase it a different way, Judge. I think would put it in a better context. Someone who does HVAC work, that goes in and puts in a temporary furnace that provides heat, okay? That, no question, would fall under the Construction Lien Act, okay? Carpet cleaning, look, if it's an improvement to the home, it falls under the act, okay?
I bring in a piano tuner from time to time to tune my piano.
Well, it's not a fixture to the home. It would be personal property. So no, it wouldn't. But if it's a fixture to the home and it's an improvement and it increases the value of the home, absolutely, they're entitled to a mechanical lien. And I think the case law I cited even addresses that. And this goes back to the 90-day period as well. Even fairly nominal changes within that 90-day period count. So picking up equipment, cleaning up the job site, that is all service provided to the job, and would permit them to file a lien within that 90-day window, which was done.
Okay, thank you. Go ahead and continue. I don't mean to interrupt you. I like to
appreciate it.
engage with some questions.
And I appreciate that, and I welcome it. The other big question here is Krista Wiley's role and Deborah Wiley's role. I think the testimony is crystal clear that Krista was acting as an agent for Deborah, who was the principal. And it's not a traditional agent-principal relationship, but it absolutely qualifies. The case law in Michigan, and I'm going to cite here from Chappa v. St. Mary's Hospital, it's 192 Mishap 29, 1991. The elements are the person dealing with the agent must do so with the belief in the agent's authority, and this belief must be a reasonable one. Well, again, Krista Wiley was there. She lived in the home. It's an emergency situation. No one had any reason to question that Krista had authority to authorize ServPro. And in fact, the testimony was that she did have authority, that her mom gave her permission to contact ServPro and get the water removed from the basement. The second element is that the belief must be generated by some act or negligence on the part of the principal sought to be charged. Well, again, Deborah Wiley testified she knew ServPro was being called. She saw ServPro's machinery there, equipment there, remediating this situation. So there was an act by Deborah Wiley in knowing that ServPro was coming, and the logical conclusion is that they're going to have to be paid for their services. And the third element is that the person relying on the agent's authority must not be guilty of some negligence. And again, under the circumstances with an emergency here, ServPro doesn't have time to, do a title search to figure out who the proper owner of this property is. They've got an agent there who's saying that they have authority. The testimony is clear that they were given authority to make this arrangement. That apparent or ostensible authority under Michigan law binds the principal. So Deborah Wiley is bound to the acts of Krista, and ServPro can absolutely, under that agency theory, as well as really an unjust enrichment theory. I mean, Deborah received the benefit of ServPro services to her home. So under both those theories, Deborah Wiley is personally liable, and her home is subject to that construction lien because her agent, Krista, signed the agreement that expressly provided a mechanical lien could be attached to the home. There's some argument in the trial brief Mr. Gaudot filed about the lien only partially attaching to Krista's interest. Well, I've already addressed it again. Krista was acting as Deborah's agent. So Deborah was fully bound. But I just want to address the idea that somehow the lien only attaches to the item worked on. That's not how construction liens work. If someone puts in, again, a new furnace, you don't get to just foreclose on the furnace. You get to foreclose on the entire parcel of property that's improved by the addition of that furnace. So I just want to address that that's really a misconception of how these work. We don't get to just foreclose on the air that we dried. We get to foreclose on the premises that we improved by helping preserve and protect that property from mildew, rot, and enabling other contractors to get in there and fix the heat, fix the electric.
Well, there are lots of rentals in northern Michigan that aren't, we don't have a lot of apartment complexes. So a lot of rentals up north are residential properties. So, you know, I know under the facts of this case, you know, that the owner's living there and you've asserted some agency theories, but setting that aside, if there's an offsite landlord, by what authority is the tenant just contracting for things and now the landlord loses their interest in the property? How does that work?
Well, again, it's a different relationship. You know, it's a different relationship because first of all, if ServPro shows up to an apartment building or in a place that, you know, is obvious that it is a rental, then they have some responsibility to question, well, wait a second, do you have authority to be signing this? But you've got someone with the same last name who lives in the home. It's a residential home and is not at all questioning or saying, hey, I got to check with my mom. She's signing it. I mean, ServPro had no way of knowing that she wasn't fully authorized to do this. And again, I think the testimony establishes she was fully authorized. I think we're kind of past the apparent authority. She had actual authority. I mean, Deborah Wiley testified, I gave her permission to contact ServPro. I mean, she was her agent. I mean, that's established.
What about Krista's testimony that she told told ServPro's representatives that she was not the homeowner?
You know, I question whether that happened. I mean, I think some of Krista's testimony was dubious in the nature of her recollection. So I question whether that happened. Even if it did happen, okay, assuming Argüendo that maybe that did happen, it doesn't change the fact that she was in fact an agent for Deborah Wiley. Again, Deborah Wiley, crystal clear. I asked her one question on cross-exam. Did you authorize her to contact ServPro to remove the water from your basement? And she said yes. So it's an actual agency agreement between the two of them. The other question I would raise, Judge, is why didn't they file a cross-claim in the litigation if they were trying to hold Deborah harmless from Krista's actions? And again, I think it's because the reality is that she was acting as her agent. She did have authority to enter into this contract on her behalf.
So I understand how that plays into your construction lien claims. How does that play into your counts for breach of contract and account stated?
Sure.
So that let's say that there was some deficiency, say the 90-day issue or something where the construction lien goes away, but you prevail on a contract theory. Who's liable under that contract? Only Krista? Or
no,
Deborah?
both Krista and Deborah. Because again, the agent can bind the principal, and the agent did bind the principal here. And again, under an unjust enrichment theory as well, because Deborah sat back and she watched ServPro do the work. She knew they were going to need to be compensated for doing this work. And I mean, look, I credit her testimony today, but in other words, I believe she was being truthful, but I mean, she was also clearly being negligent in the sense that she said, well, I didn't even read the lawsuit. I don't know. Krista was handling it. You know, I didn't really question how they were getting paid. I never talked to the insurance adjuster, you know, and that's fine. If she wants to take that approach, that's her right. But I mean, then she has to face the consequences of doing that, which is that she has her daughter authorized to do these things on her behalf, and then she's going to be bound to those things. The proper remedy would be she would then file a cross claim against Krista and say, I never actually authorized you to do that. And that's how she would indemnify herself. But that didn't happen here.
Okay, go ahead and continue.
Thank you. The last couple items I want to address, we already talked about whether or not this qualifies as an improvement. I need to address the interest rate, or the finance charge is what it actually is. And I briefed this thoroughly. I'm going to rely on the brief for the most part, but defendant's counsel's brief talks about how under the Home Improvement Finance Act, this case isn't brought under that, and therefore that's not applicable. The point I raised in my brief was that a 1.5% finance charge monthly is authorized in another state statute for doing home improvements. So to say that 1.5% monthly as a finance charge is somehow usury, our own state legislature says that it's not. I mean, they've authorized it expressly for home improvement because it's a time price differential. It's not a straight loan of money at a particular interest rate. It's a time price differential in the sense that it costs ServPro money. And you heard them talk about that, the fact that, hey, when we don't get paid, we got to float payroll, we got to cover expenses and other overhead, and the price goes up. I mean, the price for them goes up in having to essentially unwillingly finance this bill for someone when they were expected to be paid in full at the time of completing the service. So that's the difference. And I know that, it can be a bit confusing, but that's how it works. Okay. And that's why they charge what they charge. That said, the testimony was also, they only charged it for a few months. They stopped once the lawsuit was being, wasn't even filed. I think it was before it was filed. Even it was in November of 2024, they stopped charging. So the total amount of interest, I believe, is around like $250 at 7%, the maximum allowed by law. If the court believes it's an interest rate, it would still be around $175 per year. So I think we're really talking about that amount of interest anyways. I mean, I think it would be a wash, and we would be still entitled to the max allowed by law under the terms of the contract. Do you have any questions about that issue, Judge?
Yeah, just the remedy, looking at the statute, would be if there was a usurious interest on the remedy, then the seller's not entitled to interest, and the buyer or borrower is entitled to attorney fees and court costs. What would be the situation if you were entitled to attorney fees under the contract, but the defendants were entitled to attorney fees under the usury statute?
Well, I think
a wash, or do we have to actually go through the bills? And
yeah, and I would have to look at the usury statute. I don't know that it entitles them to attorney fees under the usury statute. I think it entitles them to.
It does. I double checked that.
It's under the Michigan Consumer Protection Act that they
no under the usury statute. 438 section 32.
And again, our position is that it's not usury because it's not an interest charge, but. If the court goes down that road, I guess you would then have to, analyze that about whether the court has discretion, whether or not to award those attorney fees under the circumstances. And then turning to attorney fees, we've asserted that the hourly rate at $300 is reasonable. I've submitted evidence of that. It's what I've charged for years. I anticipate filing a bill of costs if the court does award attorney fees, and laying all that out and giving counsel an opportunity to object.
Okay.
Do you have any other questions?
No, sir.
Okay. Thank you for your time.
Thank you, Mr. Slade. Mr. Kadai.
Thanks, Your Honor.